Hello everyone, this is Tom Fox. I'd like to welcome you to episode 175 of the FCPA Compliance and Ethics Report. The FCPA Compliance and Ethics Report is sponsored by Advanced Compliance Solutions. Advanced Compliance Solutions is your one-stop shop for all manner of compliance solutions, whether they be risk assessment, whether they be program creation, implementation, or enhancement, training, or a wide variety of compliance topics. Today I have with me Debra Bruce. Debra is a principal at Lawyer Coach. She is a recovering lawyer and now helps lawyers and law firms in the practice of law. We're going to visit about some of the new investment models for law firms. We're going to talk about the Gately firm in England, which recently went public with an IPO, and the implications this may have for U.S. law firms and doing business with law firms and for clients going forward. The episode comes in at just over 30 minutes. I hope you enjoy it. Thank you very much. Hello, everyone. Welcome you to this episode of the FCPA Compliance and Ethics Report. Today, I'm very pleased to have with me Debra Bruce. Debra is the principal of Lawyer Coach, a coaching firm for lawyers here in Houston, as the name might imply. Debra has had quite a varied career in the profession of law. She's been in what we now call a AmLaw 100 firm, big firm. She's worked in smaller firms, and I think you were in-house for a while, if I remember that correctly.
Oh, no, actually, I never was in-house. But
never was in-house, okay. Yeah. But nevertheless, she helps lawyers like myself. She is my coach, and she helps law firms. She lectures extensively on legal ethics, lawyers' responsibility, lawyers in social media, and a wide variety of topics. So with that somewhat long-winded introduction, Debra, welcome, and thank you for coming.
Well, thanks for having me. I'm happy to join in on this conversation.
Debra, one of the things that I've heard you talk about over the years is consistently over the years is the evolution of the practice of law in many areas. One of them is in law firm ownership and law firm finance. And one of the reasons I wanted to visit with you today is there was a recent fairly dramatic announcement out of the United Kingdom that a law firm from Birmingham, England, was the first English law firm to issue an IPO. Under English law, a law firm can have non-lawyer owners, and we've had a couple of firms that certainly I'm aware of that had non-law firm or non-lawyer partner ownership. But this is the first time we had a law firm go public, if we can use that phrase. That's something that has been, it's not anathema, certainly looked down upon here in the U.S., although you have talked about it quite a bit. So why don't you kind of get us up to the point where before this firm went public and what you saw really across the globe in this tsunami of change in attitude toward law firm ownership, financing, and partnership.
Well, you're right that was the first law firm in the UK to go public, the Gately law firm, and they raised about £30 million, which is about $38 million. They were not the first law firm to go public globally, however. In 2007, an Australian firm, Slater & Gordon, which was a personal injury firm, went public. And Slater & Gordon subsequently used some of its funds to acquire firms in the UK. So it is groundbreaking to have a UK law firm go public, but there are various other firms, as you're mentioning, that in the UK are called alternative business services. They have to register separately, but are able to get outside investors. And that's a big difference from our traditional partnership model. And one of the most significant things about that is that they have capital to invest in infrastructure, technology, or developing new kinds of systems that make them more competitive. And in the traditional partnership model, all the money gets distributed at the end of the year. There's not really much in the way of retained earnings for reinvestment in the firm.
Debra, you have talked about that concept in terms of cash available or money available for reinvestment in the firm as essentially a game changer in the delivery of legal services. What are some of your thoughts around that?
Would you repeat the last part of that? I got a little static. What?
Sure. You talked about this new model which allows law firms to have more money available for investment and potentially a game changing in delivery of legal services. What sort of led you to some of that?
So I'm still missing the very end of your question, but let me guess at it. The significance of having this money for reinvestment is to be able to do things that other firms don't have the technology to do. And so a good example of some of that, we are seeing some firms investing their own capital in that, but like, for example, there is a company called Neotologic that builds automation, document automation models for all different kinds of companies. And Cypress Shaw is one of the first big firms to contract with them to do that, so, to start automating their document generation. But another example of being able to use capital in a competitor to most current legal services would be Axiom, which is not actually a law firm, and that's why they're able to raise all of this capital. They raised about $28 million, I think it was in 2013, and they invested it primarily in technology. And they just recently announced this year that they got a $73 million contract from a major bank to be doing sort of process management for that bank. So they're going through all of their contracts that have to do with their swaps and stuff like that and the high complex financial transactions. And they use lawyers to review them and paralegals, but it's because they've got this workflow process that allows them to do it efficiently and to find deviations from their standard model very easily in analyzing thousands of swaps contracts, trading contracts. Does that make sense, how I articulated that?
Well, and in fact, I would say in my world that's called using data analytics to pick
Yes.
up exceptions or something outside the range you set as your statistical norm, and you flag those for further investigation by a subject matter expert. Absolutely.
Exactly. And it is particularly in the compliance world that it's helping them both manage their risk more effectively and cheaper.
So I guess what I've heard you articulate over the years, and certainly in that answer, was that companies or law firms, rather, that have additional capital for technological investments can deliver a more efficient legal services to a client, which may put them at a competitive advantage to traditional law firm models.
Yes, they can do it more efficiently, more both cost effectively, quicker, and at a higher quality level. And we're seeing a lot of what you would call disruption of the market. If you're familiar with Clayton Christensen's book, The Innovator's Dilemma, he talks about disruptive services, disruptive products, and he gives the example of Southwest Airlines. And what happens first with this disruption is that they go into the lower cost services or products where the big players don't really care too much about losing that market, or maybe they don't even want that market at all, which is what Southwest Airlines did. They came in and got the low cost, low value, small, short trips, and so the big airlines didn't really care if Southwest Airlines undercut them. But they had some better methodology, and they, among other things, they only used one kind of plane, one kind of airplane, so they cut all their maintenance costs and other kinds of things by doing that. And, of course, as you know today, Southwest is a good example of how they start at the bottom of the market, and then they start getting very efficient at it, and people see them and like it, and they start to get a bigger and bigger chunk of the market and start moving up the food chain. So right now, Southwest is one of the most profitable airlines and has been for a decade or two. So what's happening in the legal market is something like that. So it started out with legal process outsourcing to India and such. And now today, what's happening is that those firms that can invest in technology can start picking stuff off by being more efficient and cost effective. And even big firms can do it, but most of them are not because they're still stuck in their old model.
But you've seen examples of big firms that have used a non-traditional approach by either forming another firm, forming corporations to deliver a specific type of service. Could you give us some of those examples?
Well, Seyfarth Shaw that I mentioned a minute ago is a good example of that. They have actually created a separate entity, which is called Seyfarth Lean, and they are actually doing consulting about how to use the Lean model, which is a Lean Six Sigma kind of thing, is something the corporate world went through, was very popular in the corporate world in terms of improving efficiency and reducing errors, shall we say. So that's what they're offering to their clients, whether it's an in-house client that we can come in and use a better workflow process that is quicker and more effective, like we were just talking about with Axiom, or they can do it themselves more cost effectively. But they have, the way they're getting around some of the issues about that capital issue is having a separate consulting arm now. But there are some other kinds of examples of where big firms are trying to do things that capture that small, low-cost business, at least initially, like in the startup world. Some of the law firms, like Orrick and Wilson Sonsini and Littler Mendelsohn, are creating, they have on their websites these free resources for startups. Orrick calls it their startup tools kit, and Wilson Sonsini calls it their term sheet generator. So they're actually offering some of this traditional legal service for free as a sort of a loss leader for later having loyalty from those people as they grow and are ready to be successful businesses.
One of the things that intrigued me about the gateway firm in the United Kingdom was that in their offering, or at least in the descriptions I read, that the investors would receive approximately 80% of the firm profits and the partners 20%. That's quite a change from the traditional partnership model, or at least when you and I started practicing law, what we might expect as a partner. Do you see any implications from that?
Well, that's one of the things that's significant about the Gately model is that 81 partners sold some of their shares in the firm. So, yes, it is different. I'm not certain that that's what it came out that way, that the investors are going to own 80%. I know that 10% of Gately's own existing clients actually bought shares in the firm, and they were going to own about 3.8%. That's the numbers that I saw. The partners that sold, they sold about over 30 million shares, and that was about 30% of the firm. So maybe it does come out to be pretty close to that. If not 80-20, maybe it's, well, I don't know. But that's certainly a big difference, and one of the things that's likely to happen in that firm is that individual lawyer salaries are going to start coming down significantly.
Mm-hmm. Right. So what do you think that I see some significant ethical implications from this, because one of the things that certainly you and I were taught was that the lawyer's first duty is to his client. And is that going to change, or is it in danger of changing if you have a corporate parent that is the owner, that you as an employee owe a duty of loyalty to the shareholders, stockholders, or owners of the company?
Well, that's what you hear as the argument against this all the time, is that, well, that's going to change, this duty, and it's going to erode this ethical duty to clients. I think that's a little disingenuous because there is a huge demand for profitability within law firms now. And I think it could be argued that there has already been an erosion of ethical duties to clients in terms of putting profits before clients' interest. Now, that sounds really harsh, but most of us may have seen some situations. One that kind of stands out kind of big is how we're able to get around something that looks like a conflict and decide that it's not a conflict. And I've seen some situations where I do not see how that's not a conflict. And this, and whether it's big firms or small firms.
Right.
So I think there already is that profit pressure. So it's I don't think it's necessarily going to be greater.
Mm-hmm.
And I have certainly seen situations where partners are wanting to, the client is asking the firm to do something, and the partner who stands to gain the most financially is advocating very strongly for that, and when it's really dodgy ethically. I've personally seen specific examples of that.
Right. Do you think that this new model could lead to I don't want to use the word differentiation, but sort of a different levels of, I can't think of the right word, but not profitability of law firms, but different levels of or striations of law firms. So you might have the traditional white shoe law firm, New York, Houston, you name the big city, really at the top. Then you have mid-level firms, and then you have this hybrid model that has gotten investors from other sources that can deliver a more cost-efficient product that perhaps needs a lower level of subject matter expertise. Is something like that something you might see down the road, or is that off base as well?
No, I think absolutely you'll see some things like that. I think that it's going to be really getting pretty tough for small and solo firms because organizations with this powerful technology sort of like looking at tax return preparation. A lot of people use TurboTax that might have used CPAs in the past, for example. Now, that doesn't mean if you've got this huge, complex organization with lots of accounting going on that you won't still need CPAs. But the more consumer level type of work is likely to be gobbled up in a lot of instances by something that is more technology driven. But I also would not be surprised to see, just like we were talking about with some of these big firms having their loss leader with the startup toolkits, for example, that they might create an arm that is actually, if they have the investment in the technology, that's competing with Legalzoom for startup businesses, for example, providing very low-cost businesses and low-cost legal services that are on a different kind of profit margin than their what is getting referred to a lot here in the U.S. and always was in the U.K., bespoke legal services.
Right.
Customized legal services as opposed to, the TurboTax kind of services.
Right. Let me pose perhaps an ethical issue another way. It's something that I've been thinking about as well. And let me take it down to the world I practice in compliance, specifically anti-corruption compliance.
Mm-hmm.
Obviously, there's a legal component. There's a U.S. Foreign Corrupt Practice Act or other laws that lawyers need to be aware of, and they need to be able to interpret and articulate to clients. They need to do investigations, either lawyer-driven or as lawyers advising on the investigations.
But a large part of anti-corruption compliance might be termed business processes. And designing processes so employees are trained, employees are checked, employees know what the rules are, and if they go outside the rule, they seek an appropriate level of approval, that sort of thing. That occurs many ways and many times in other business processes. If a law firm moves towards automating some process, and the process you described where you're looking for an exception in hundreds, thousands, or millions of transactions to be flagged for further investigation, does that come close to blurring the line of what's a delivery of a legal service versus what's the delivery of some other type of service which could impact the attorney-client privilege?
Oh, now that's a really interesting aspect of it. I think we're going to see a lot of blurring of the lines of what's a legal service, what's being provided by lawyers, and what's being provided by non-lawyers. That's an interesting argument about the attorney-client privilege, and some of that might be resolved in the kinds of ways, for example, that Axiom is doing this. So Axiom is doing just what you were saying with this $73 million contract that they got. They're analyzing all of these documents and look, here's our standard form, and then here are all our standard kind of clauses, and picking out all of the exceptions to their standard clauses to be then reviewed by lawyers that work for Axiom. But those lawyers are not, Axiom is not a law firm, and they're kind of calling it's sort of like back office management or being a managed services provider. So in law firms today, you have providers that come in and manage a lot of the back office stuff, the IT, the copying and delivery kind of stuff, and they're not lawyers, and they are seeing or have access to see lots of legal documents. So I think it would get resolved by way of having lawyers involved somewhere and having those people enter into non-disclosure client confidentiality agreements with the lawyers.
One of the things you've talked about is not only the funding advantage that a United Kingdom law firm might have, but the technological advantage that they could bring to bear in the delivery of a legal service, and that U.S. companies might be enticed to sign contracts with these UK firms because of this technological advantage or ability to deliver a more cost-effective legal solution, and that might drive U.S. Law firms to make changes. But here in the U.S., although we have an American Bar Association, we also have 50 states which regulate the lawyers' conduct in each state. Could you foresee a situation where one state might change its rules and gives that state's lawyers a competitive advantage in this type of situation?
Certainly the rules will be changed on a state-by-state basis unless there is a lawsuit that finds, sort of like in the 70s when it was the
lawyer advertising.
Right. So there may be something like that is happening, and so there's a couple of things going on. Legalzoom is in litigation with North Carolina, and I don't know what the current status of this is. There is a law firm that's kind of it's a consumer level firm that handles some personal injury and bankruptcy, and they're not here in this area. Like they're in Chicago, but it's a number of places across the country, and at the moment the name of the firm is slipping my mind. They were bringing suit against Connecticut, and maybe it was New York, claiming that this prohibition against outside investment was an illegal restraint on trade, and I don't know what all of their legal arguments. I don't remember all of their legal arguments about that. But some of those may wind up being successful claims. And if that is the case, it may not have to go on a state-by-state basis if the Supreme Court winds up ruling on something. But otherwise, it will be a state-by-state situation. And by the way, in Washington, D.C., non-lawyers can have an ownership in a law firm. I don't think many people know that. That's primarily for lobbyists to be able to share in the profits there, but it's not so far away and foreign as we might think. And when we've got this global economy, which we do have, and the same company is using firms in London and New York and Hong Kong and so on, if they can get better services out of London, they may be, faster, cheaper services out of London. They may contract with the London firm, and that London firm may have some law firms that they consult with, or some U.S. lawyers that are resident in London, and still be able to provide the same kind of services maybe that could be provided by New York. Mm-hmm. So that's once that starts to happen, when big firms in the UK can have better work process systems because of their technology, and they can provide the same quality of expertise at about 50% of the cost, there's going to be huge, which is not at all. I mean, I don't know if you're laughing because you don't think that's going to happen, but I think it really will.
No, I'm laughing because you're right. It's coming.
Yeah.
That's exactly the manner it is. And I'm just wondering if you're seeing an adequate response to this disruption in the United States, whether that be state bars, whether it be people like you and me talking, whether it be law firms really thinking about it, or is it just the axioms of the world that have really thought this through?
I think that that the vast majority of lawyers have their head in the sand about this. One part of it is that lawyers are working harder today than they used to have to, and they're grinding away more, and so they're not as aware of what is going on in the world around them. Mm-hmm. But the other part is it is so easy to say, oh, that won't happen here. Because it's sort of like they're not listening to the conversation that's going out in the world around them. They don't know about these developments. And then when we try to be the Paul Reveres and say the British are coming, they're not wanting to listen because it either means because it's just so difficult to change. One reason why it's so difficult is lawyers are a little bit technological dinosaurs as a large group.
I agree with that 100%.
So if they haven't kept up with the technology learning curve now, mm-hmm. it's too big a leap for them. So they just kind of go into denial. But I think in the big firms, they're seeing that model is already changing, but they can't quite figure out how to go. Well, we started with laying off a lot of support staff and laying off associates, and then we started, pushing some partners out that we didn't think were profitable. And maybe that's a better model, but they're still not doing value-based pricing very much. However, there are law firms now that have people, they're pricing experts in the firm. So Aiken Gump, for example, has Toby Brown, that's his job, is to help the firm pricing their offers to their clients. So that didn't exist 10 years ago. That's a job title that didn't exist in
Right.
law firms.
Well, Debra, unfortunately, we're nearly at the end of our time, but I was wondering if someone wanted to follow up with you or perhaps get in touch with you to visit about some of these topics we've conversed about. Could they email you, and if so, how would they do it?
Absolutely. I would be happy. It's one of my favorite subjects, and I would love to be talking to people who actually want to learn more about this, because it's a grave danger to the survival of a lot of lawyers. And my email address is Debra, Debra, at lawyer-coach.com.
Well, Debra, thank you very much, and you've certainly given me a lot of food for thought in my little practice. I hope others may, whether they be in law firms that have listened to this or perhaps even clients, corporations, giving them some pause for consideration on how they may purchase legal services. So I look forward to continuing the conversation.
All right. Thank you, Tom, and I hope we have even more interesting things coming to the future conversations. It's actually kind of an exciting development. It may be dangerous for lawyers, but it's still exciting because it's so novel.
All right. Thanks a lot.
All righty. Bye-bye.
Bye.
Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to episode 175 of the FCPA Compliance and Ethics Report. If you'd like more information, I hope you will contact me at tfox@tfoxlaw.com. I also have 2 calls to action. The first is, if you enjoyed this podcast, if you could rate us on iTunes, it would certainly help get the information and name of the podcast out so more people can enjoy it and perhaps learn something from it. The second is, if you have any questions, please send them to me. I'm preparing my second mailbag episode. Once again, you can email me questions at tfox@tfoxlaw.com. Thank you very much.